there are other rules that are really important to know, because there are rules that say you can give away assets and there's no penalty period. So transfers which cause no penalty, already talked about outside the 5-year look back window. You can give your home away to your spouse, which doesn't really help because both your assets count, but we'll talk about that. To a disabled child, also to a minor child, a child who is a minor, a sibling with an equity interest, or a caregiver child. Now be careful. A caregiver child transfer exemption is really technical. So I want you to be aware of it, but please don't try it on your own. Talk to an attorney, an elder law attorney who has helped a client give away the home to the caregiver child, and with no penalty, then they go receive Medicaid benefits. You can also give away your assets to a trust that's for the sole benefit of what we call a qualified beneficiary. So that's your disabled child, or to any disabled person. Doesn't have to be your child. As long as that person is under age 65, you can transfer assets to a trust for their benefit. Whereas with your child who's disabled, you don't have to give it to a trust. You may want to, you may not, depends on the situation, but you can give away all your assets to your disabled child, and there will be no penalty. So rather than having to spend down the assets, you give them to the disabled child, and then you know that those assets are preserved. Now, what they do with those assets is subject to a different conversation, but what I want you to be aware of is that this is a very, very useful rule that allows parents to transfer to their disabled child all of their assets. There's also the possibility of giving away the person who needs Medicaid to what is called a D4A trust. That has a payback to the state. But it is something that could be quite useful. There's also something called a D4C trust, but that does cause a penalty transfer. And then once somebody is on Medicaid, they should take action to avoid the state's lien. This community first choice program that we talked about a little bit earlier, there's no transfer penalty. It has the income rules and resource rules that you can only, you're a single person, you can only have $2,000. Okay, let's say you have more than that. You can give away all of those assets and there's no penalty. And during the penalty period, there's no penalty for benefits being paid under the CFC program. There will be a penalty imposed for the COPES program. Okay, that's fine. You don't care because your assisted living or your adult family home, or if you're at home, your care is going to be paid for by the CFC program, even though you gave away assets. And the general rule is you can't give away assets without losing benefits. For CFC, you can give away benefits and get CFC to cover your community-based care. One of the things that CFC won't do is cover care if that person's care needs increase, they need to move into a skilled nursing facility. There is not going to be any benefits to cover for the care, and that's a big problem. There should be a plan in place for that, including the person who received the gift to return all of the gift. Because if they don't, Medicaid might cover the care in the skilled nursing facility, but they impose a penalty, 150% penalty against the gift recipient under this hardship exemption. So one of the things that is a very valuable planning tool for those who qualify for the CFC program is a transfer of assets to whomever the Medicaid client would want the assets to transfer to, and no penalty associated with that transfer.